Caveat emptor. This ancient rule, meaning buyer beware, conjures up images of the snake oil salesman, the flimflam artist, and the con man, ready to say anything to make a sale, and all too willing to abandon the buyer if anything goes wrong. The rule can be harsh, and the larger the purchase, the greater the risk. A house is one of the largest purchases most people will ever make. Should buyer beware remain the rule of the real estate market? Let's see how the Florida Supreme Court answered this question in the landmark case of Johnson versus Davis. The buyers, Morton and Edna Davis, agreed to buy a house from the sellers, Clarence and Dana Johnson. The contract required a $5,000 initial deposit, followed by a second deposit of $26,000. The contract gave the buyers the right to inspect the roof to make sure it was watertight. The sellers were to pay for any needed repairs. Before the closing, the buyers noticed some water stains and peeling plaster in the house. The seller told the buyers that these were caused by minor renovations. The buyers then paid the second deposit. A few days later, the buyers visited the house after a heavy rain and saw water gushing in around a window and through the ceiling while a cleaning crew scrambled to stem the tide. The sellers claimed the roof could be repaired for about $1,000. The buyers thought the house needed a whole new roof for $15,000. The parties couldn't agree on a solution, and the buyers sued the sellers for rescission, seeking to nullify the contract and recover their deposits. The trial court granted rescission and awarded the buyers their $26,000 deposit while allowing the sellers to keep the initial $5,000. Both parties appealed. The Court of Appeals awarded the buyers both deposits, or $31,000. The Florida Supreme Court granted review.